on behalf of Themis, the Intersectional Women's Barrister Alliance. So I'd like to start by introducing Themis and intersectionality as a concept. So when one Googles intersectionality, as many of you may have done, the Google definition comes up as this. Intersectionality is a noun, and it's the interconnected nature of social categorizations such as race, class, and gender as they apply to a given individual or group, regarded as creating overlapping and interdependent systems of discrimination or disadvantage. Now, the example sentence given is, through an awareness of intersectionality, we can better acknowledge and ground the differences among us. And that's exactly what Themis stands for. We believe that with an awareness of intersectionality, we can improve the bar for all of us, but particularly for those of us that may not find it as easy or as accessible as many of the traditional members. So Themis was created by 3 women, 2 of whom are practicing barristers and 1 of whom is completing her BPTC at the moment. And it's born out of this desire to promote an activist, progressive and intersectional agenda aimed at representing the interests of all self-identifying women at the bar. Now, it was chosen to create a completely new alliance to fill what was perceived to be a gap. One of the key pillars on which Themis was built is the understanding that equality can only be seriously advanced working collectively with other underrepresented groups at the bar. And that's why events like tonight are so fantastic, because it really gives us an opportunity to put our money where our mouth is and really show that we are working with all groups at the bar to promote diversity and equality. Now, for that reason, since starting work on Themis this April, the founders have consulted widely with individual women barristers, other groups with similar values, and the Bar Council, including neurodiversity in law. So the feedback we received has largely shaped our decision-making, and it's absolutely how Themis is working and planning on continuing to work. I'm really honoured to be a part of Themis's steering group. Now you can find information about the rest of the steering group on our website, but I have to say it's so wonderful to be part of such a fantastically diverse group of women at the bar, particularly for those of us that practice in a traditionally male and more white practice area. So obviously I need to make this plug. If you would like to work with us, if you would like to join us, please do. I'm sure all of you have got our email address and indeed our website link through Instagram or Twitter, however you joined up. We also have a blog, which I think is starting to welcome submissions, although I'm sure I'll be told off if I've preempted that. And we'd be very happy to join forces with any of the other groups out there who are interested in promoting intersectionality and diversity at the bar. One thing I would like to say is this: Themis is still at the start of its journey, and we're really keen to work with as many people as possible to make sure that we're able to really push for progress at the bar. So if you are part of another group or if you have ideas, please do join us either as a member or an ally. Now, I'm going to be as brief as possible, but before I hand over to neurodiversity and law to introduce themselves, I would like to introduce our keynote speaker. Apologies if you guys can hear a sort of beeping in the background. That's actually the Themis Slack group talking about this event as we're going on. So I do apologise. And also I have a cat that appears to be going mad behind me. I am sorry. I'm back at my parents' thanks to Tier 3. So let me now turn to introducing our keynote speaker, Bree Stevens-Hall QC. Bree has a successful property practice which focuses on real property as opposed to intellectual property, which is my own area. So I'm afraid I can't really comment on her work, but I know she's fantastically successful and widely ranked. Practice-wise, she's developed a strong reputation for her contentious probate work, which also frequently involves property issues and property-related sort of professional negligence, probate, and franchising. She's also recognised as a great mediator. Now, many of us at the bar will also know Bree as a fantastic advocate for diversity and someone who we really look up to as often being, at the absolute forefront of these kind of events and these kind of movements. And I'm so honoured to be able to introduce her this evening. So now let me hand over to Sophie Stevens, who is Head of Media and Marketing for Neurodiversity in Law. Now, many of you will have seen Sophie's profile on all of our promotional material, and I understand you're getting a brochure in relation to this. So she's currently studying the BPTC and is really interested in a common law practice specialising in crime. And it's so exciting to have someone really at the forefront of their practice, looking forward to working with us and indeed neurodiversity in law for intersectionality, promoting intersectionality. So that's me. Please do join us at Themis. Have a lovely evening. And now I will hand over to Sophie.
Hi all. As Beth mentioned, I'm Sophie from Neurodiversity and Law, and I'm just going to tell you a little bit about what neurodiversity is and how ND and law came to be. So neurodiversity and being neurodivergent simply means that in its basic form that we think differently. It's an umbrella term for different conditions, and I will name a few: dyslexia, dyspraxia, dyscalculia, ADHD, visual processing disorders, and autism spectrum disorders. And that's just to name a few. What neurodiversity affects is memory, communication, mood, attention, and a range of other things. I think it's important to know that being neurodivergent isn't just one set thing, it affects every single person differently. No brain is in essence the same. That's a concept that we're all well aware of, being human. But these conditions that neurodivergent people have make that concept more extreme in daily life, and particularly in practice at the bar. Another thing that's important to note about neurodiversity is that not all people with a neurodivergent condition identify with having a disability. It comes under the Equality Act, but not all people feel that being neurodivergent means that you are disabled. I personally, myself being dyslexic, don't identify as having a disability. I simply say that I am neurodivergent, and we at Neurodiversity in Law feel it's really important to make that awareness clear. There's not really much else to say about neurodiversity as what it is, other than it in its broadest term is we all think differently and we all work differently, and that's what makes us neurodivergent. Now, NDiL law itself was set up during lockdown round 1 after a tweet was sent out by our chair, Thomas Hood, asking if anyone in the legal profession, students, current practitioners, had neurodivergent conditions and wanted to basically have a chat. These people reached out to Tom, including myself and Roxy, who's here this evening, and about 12 of us who were particularly keen ended up, after many Zoom calls, deciding to set up an organisation to fill the gap that was there for neurodivergence in the legal profession, and those people now make up our executive team. We worked tirelessly over the lockdown period discussing our aims and what we wanted to get out of this very early on, as we were really aware that there was not much out there for neurodivergent people in the legal profession. So we ended up launching in October, after establishing what these aims would be, which you can find on our website. And we continue to see that the word neurodiversity in itself wasn't particularly covered at all or discussed within the law. So our primary aim, and it still is at the moment, is that we want to change that. We want to just create that awareness. So our main purpose at present is to simply promote and support neurodivergent individuals within the legal profession, getting everyone involved, whether you're a barrister, solicitor, or legal professional, and eliminate that stigma that is often associated with people who think differently. We think it's really important to show that neurodivergent people in the legal professions have something to bring, that the stigma that's there is often very much focusing on the negative, and we want to flip that at NDiL law and focus on the positive, that there is a huge amount to gain from being neurodivergent and recruiting neurodivergent individuals. Dyslexics, for example, have a tendency to be able to think outside the box and be more empathetic, and those skills are great for the bar. We also at NDiL law aim to show that neurodiversity isn't linked to intelligence. Just because you're neurodivergent doesn't mean you can't do what people without neurodivergent conditions can do. We also think this whole concept all the time is discussed about our legal sector should represent society, and I feel really strongly in that, and I believe our other panelists will agree that is something that's really important, regardless of what we look at and on the diversity spectrum. And around 15% of people in society are in fact neurodivergent. So we believe at NDiL law that the lawyers representing these people should also be neurodivergent too. We will have neurodivergent clients, and there's no one better to understand those clients than neurodivergent lawyers themselves. They can understand and support, knowing how they process information, how we process information, and that is a benefit to the legal profession, and that in general is what neurodiversity in law is about, incorporating all those things and making the profession more aware of what it can gain from it. To close up, because I know the panelists hopefully will answer more questions and more about this throughout the evening, I echo what Beth said earlier, that we are looking to work with everyone and anyone from other organisations to create a supportive network in regards to diversity. And if you wish to join us, you can do so via our website and check us out on all our social media platforms in order to learn more. So thank you for listening to me and learning a little bit about neurodiversity. I'll now hand over to Bree, I believe, for an introductory keynote.
Thank you very much. I'm very flattered to be asked to come and talk at this event. I think it typifies what is making me really excited at the moment, that actually we've reached a moment in time where there could be a really huge push forward so far as creating an inclusive culture, a culture that understands intersectionality and creates space in which all those who have the skills, the intelligence, the drive to fulfill a career at the bar have the opportunity to do that. I don't claim to be an expert, and I'm going to start this by saying I am very ignorant when it comes to neurodiversity. I was very clear with Roxy when she asked me, but maybe that's part of the value. I've been in the law feeling other in various respects for 34 years. And so really what I'm going to say comes from my experience, my sense of humanity, and my reflections on my journey. There's lots of academic stuff out there about inclusivity and about intersectionality, some of which I have managed to absorb, listen to, read, nowhere near as much as I would like to. But from my experience, I observe that most people access these concepts either from their own experience as a starting point or from the experience of someone who is very close to them. And what I mean is the experience of being other, and to use the sort of language that would be used in our profession. My sense for most of my time in the profession has been, this isn't my club. It's their club. It's not my club. I don't belong here. Not quite sure how I landed up here. And I haven't stopped feeling that to a large extent. But experiencing that and nevertheless working in the profession and working to try and shift some of that, I think I've learnt a lot about, from my direct experience as a woman, and then as a member of the LGBT community, and then starting to work with other groups that I'm not a part of, but an ally to. You start to understand the mechanisms that operate, the way that being in the group and outside the group, with privilege, without agency, actively being discriminated against, passively being discriminated against, the way all of those mechanisms work in terms of external barriers, but also internal barriers. So in the LGBT community, internalized homophobia and transphobia is well understood. When you live in a society that is telling you things about a fundamental part of who you are, it's very hard not to absorb some of that. And many people do absorb it to a large extent. So being other in some sense can give you the ability to have some insights into others' experience. But what it actually teaches you is that you can't know, see, and understand everyone else's experience. many of the ways in which people are other are visible, and many others are not visible. And both of those present their own issues, and neurodiversity seems to me to be actually a group that experiences both the visible and the invisible. The visible, you're having to live with it in your face every day, how the world reacts to you. The invisible, you're having to make choices about whether you hide a fundamental part of you or not. And that has an impact on you as well. And so from all of that, we have a need for safe spaces, a need for neurodiversity in law as a collection of people where they know that there is a shared experience or allies supporting, but also we need what Themis is doing and cooperating here with neurodiversity in law, which is also to come together to do the work, to come together to use that shared experience, the shared purpose, to actually try and learn much better, to have the conversations that help a much wider group of people, hell, everyone, understand that they can't know, understand and see exactly who everyone is. So we need to create ways of talking, ways of being and ways of organizing that are respectful of everyone, that allow space for everyone to bring as much of themselves as they want to be visible and public, and to feel safe to do that. And as individuals, that means, so for me, I've learned I have to learn to wear my own ignorance, take responsibility for my own ignorance and changing that, learning about, and I'm delighted because I can't stay tonight that I'm going to be able to see the recording of this, because I was very sad about not being able to stay, but being prepared to put the work in to learn, being brave enough to make mistakes. And that can be really hard in the environment we have at the moment, where offence is taken very easily and then discussion gets closed down and we don't learn because we're too scared to ask, we're too scared to put a foot wrong. And that takes everyone being prepared to be brave and be prepared to say, I'm really sorry I got that wrong. That really wasn't my intent. I will take responsibility for doing better next time. And others being patient when they can see that that goodwill is there. So collaboration, it seems to me, is vital. I said I thought we were at a moment in time where things could really change. There's a critical mass of all sorts, an amazing array of other coming into the bar. From an intergenerational point of view, I can feel and see that there are much younger entrants to the bar who are coming with far more confident voices about who they are and what they want the bar to look like. You now have amongst the seniors, and as the generation, I put my hands up, we haven't done a great job. I thought, just a few of us coming in and being different would change it. Didn't work. But you do have a number of more senior people who are looking for opportunities to help pull up those who are wanting to step up. And so, for instance, at the moment, the thing I'm working on that I'm most excited about is the Bar Council's leadership programme as exactly a mechanism by which we can enable a richly diverse cohort to step up more quickly and more comprehensively than they might otherwise have done, to see themselves as the leaders many of them already are, and certainly fulfilling the potential they have, to actually show a very different face of the bar. So I'm going to shut up and commend this sort of collaboration. Long may it continue, both organisations separately and working together to provide those safe spaces, but also the power of allies driven by a shared purpose that can really make a difference. Thank you for listening to me.
Thank you so much, Bree. That was really insightful. And I think there's so many exciting things to look forward to, particularly the Bar Leadership Council on the day when the Silks list was announced, seems very prescient. And it's also really exciting. I do feel like the bar is a time of change, and having only been at it for a few years, it's lovely to know that that is something that everyone, you know, from us very junior to the more senior, are really excited about. So Bree, thank you so much for your time. I know you have to go off for a Chambers party, but let us know what you think of the rest of the event.
I will. I'm sad to go, but thank you.
Thank you so much. I'm so delighted now to introduce you all to Shrishti, who is a member of the Themis steering group alongside me, and we have such a fantastic time on our steering group meetings. So Shrishti is a tenant at Coram Chambers. She commenced tenancy in October of this year. So she's busy working very hard to build her practice in all areas of family law. She's also, really excitingly, part of the founding committee of Bridging the Bar. And this is another really brilliant example of all of those groups trying to promote intersectionality at the bar, coming together and really making sure we can make it a better place for everybody, and particularly those who need our support. Now, before I hand over, quick point, if anyone does have any questions, please do ask them in the chat function. Obviously, we won't have time for all of them, but we'll try and answer as many as, or rather Shrishti will absolutely be addressing it to as many people as possible. So please do ask them, and thank you for joining us. Over to you.
Hi everyone, thank you so much for allowing me to be your moderator tonight. I was explaining to the panelists that it's my first time moderating anything. I'm usually arguing in court, so you know, being the person presiding over things is a bit of an unusual position for me, but one I hope to fulfill well nonetheless. We've got an absolutely brilliant panel for you tonight. I'm really excited to be working with them, and I'd also like to thank both Sophie and Bree for their wonderful speeches, which gave us a lot to think about in terms of how this discussion will go. I'd also like to thank Beth for opening the event. I'm really excited with the work we're doing with Themis and the other organisations with whom we're working. So really pleased to be here, yeah. So in terms of our panel tonight, we have Elaine Banton, who is a barrister at 7 Bedford Row. Elaine specialises in employment, equality, discrimination law and human rights. She's been recognised in both Legal 500 and Chambers and Partners, regularly instructed in high value and complex trials by private companies, public sector bodies and individuals. She's co-author of the chapter on human rights and employment law for Tolley's Employment Law. She's named a pro bono hero for 2009 by the Attorney General's Office. She's a member of the Temple Women's Forum Committee. Elaine is co-chair of the Bar Council's Equality, Diversity and Social Mobility Committee, and she's on the Bar Council's GMC. She is also co-chair of Middle Temple's Race, Equality, Inclusion and Anti-Racism Working Group. And perhaps one of the questions tonight will be, Elaine, how do you use the same 24 hours in the day as the rest of us use to do everything that you do? It's simply amazing. We also have with us tonight Sophie Miles, who is a barrister at Doughty Street. She practices in all aspects of mental health and disability law, a focus on cases in the Court of Protection and the inherent jurisdiction, inquests and inquiries. Sophie's very busy Court of Protection practice includes personal welfare, international adult protection, medical treatment and property cases, as well as challenges against deprivation of liberty authorisations. She also advises in all areas of mental health law, where her very long experience as a mental health solicitor gives her a very practical understanding of the issues. She acts in appeals to the upper tribunal and displacement of nearest relative applications. We have with us Chloe Branton, who's a barrister at Park Lane Plowden. She's regularly instructed in both public and private law children work across the North Eastern Circuit. Chloe was selected in 2020 to be a social mobility advocate for the Bar Council as part of their #IamTheBar campaign. She has a very keen interest in promoting diversity and access to the professions. She participates in outreach events for students and career changers interested in a career at the bar with the Inner Temple and the Bar Council. And last but not least, we have Roxy Lakshowitz-Martin, who has just completed the BPTC, and she's the policy manager for neurodiversity and law. Roxy's half Persian, half Russian, the first of her family to attend university in the United Kingdom. During her GDL, she was diagnosed with 2 neurodivergent conditions, and she had a 5-year career in politics and an undergraduate degree from Durham University. She's an aspiring chancery and commercial barrister. So welcome to Roxy, welcome to all of our panelists tonight. Thank you so much for being here. Now, just to throw open a question to the panel, which we will be discussing various themes that came up from what was said and what's going to be said for about 20 to 25 minutes, and then we'll open the floor more generally to questions. But in terms of the first question that I and Themis had, what does neurodiversity in the law mean to each of you with your different experiences? Perhaps Elaine, you could start us off. Elaine, I'm so sorry, you're on mute.
There you go. It wouldn't be a seminar if somebody didn't do that. So, okay. No, thank you very much. I think neurodiversity in the law, what it means, what it represents should be that we need, as we talked about before, representation matters, and it's important that the bar reflects the society that we are seeking to serve. And we've heard about the number of individuals in society that are neurodiverse. And so it's really important that we see a reflection amongst the bar and legal profession generally, I think. But certainly speaking from position of the bar, we want to make sure that people have an opportunity to take part and become barristers, whether or not they are themselves personally neurodivergent. And I think there are so many opportunities to really encourage and support this. And in terms of the advantages it brings, just generally, as everything we know about diversity, is the more diverse and inclusive an organization is, or a profession is, for example, the more innovative, dynamic, and successful that organization or profession is. So from my point of view, I think neurodiversity in the law means that we are embracing and we are being inclusive of all individuals, including those who fall into neurodiversity and who have different ways of thinking. And I'm really excited to explore all this in the conversation. So I'll wrap it up there.
Thank you so much, Elaine. Sophie, I wonder if we could have your thoughts.
Well, it's hard to add to what has just been said, really, in terms of the legal profession. I mean, I have a few more thoughts about how those who are neurodivergent access the law, because that's very much been part of my practice. And you'll have seen from what you've kindly read out about my work is that most of the work that I do involves people who have some kind of a mental health or mental capacity condition that has brought them in some way, or their family, into an interaction with the law. And I've been thinking quite a lot about how those who I'm representing or whose families I'm representing access the courts, and how well equipped or otherwise the courts are to give them the fair hearing that they need. So that's something I'm interested in talking about with all of you during the course of the evening, looking a little bit outside the bar itself to those who we're representing.
Thank you so much, Sophie. And that's something we'll definitely touch on during the course of the evening. Chloe, I wonder if we could have your thoughts.
Well, to sort of piggyback on what's been said by both panelists so far, I think for me it sort of means an amalgamation of those two things. From the work I do with mainly students and those interested in a career at the bar, what I tend to see is that those who are neurodiverse often feel quite failed by the policies that are in place in their education around reasonable adjustments and equal access. And in some respects, that can be a great motivator in bringing those people to the bar and bringing the skills that they've got from having to often fight themselves to get access to things that they should already have. And then on the other hand, it can also be quite a disheartening process for people. And the amount of students I've heard from who said they decided they couldn't have a career at the bar because they're neurodiverse. And so to me, neurodiversity at the bar is about bringing together people who are neurodiverse and who aren't neurodiverse to harness the potential of those who are, and to encourage those who aren't to see the assets that can be brought by those people, but also to step back and realise what it really means to make, say, reasonable adjustments, and I think part of it's policy and culture, and the idea of at the bar we have to work hard, and that if you have some sort of condition that means you can't work as hard in someone's eyes, that means you can't do it, when in reality we all have different ways of working. It's just that some of us have a diagnostic label that can explain that.
Thank you so much, Chloe, for that. And last but not least, Roxy.
Yeah, I think I would also emphasize Chloe's perspective on this. Just for me, it's a community of people who are experiencing the same things as me, and allowing us to all go through it together is a real plus. And also, it's just an opportunity for us to change perspectives of people at the bar about what neurodivergent people can do. As Chloe said, there's no reason for someone who is neurodivergent not to pursue a career at the bar. The conditions that most of us have aren't a be-all and end-all end to a career at the bar. There are lots of different ways that the bar could accommodate neurodivergent students, and that starts, as Chloe said, with recruitment and with reasonable adjustments and all of those kind of things. So for me, just an opportunity to change people's perspectives.
Thank you so much for that. What's really interesting from what you've all said is the different parts of the bar that have essentially been addressed through the lens of how we consider neurodiversity. So for example, Elaine has talked about representation, which is something that is important both at the entrance point to the bar, but also for people that are already in the profession. Sophie's talked about how we approach our clients and our practice through that lens. And Chloe and Roxy have talked a bit more about recruitment and how to make people that feel maybe like it's not an accessible career, feel more like it is a space in which they can exist. And Bree, in fact, in her opening speech brought up that we need safe spaces. Essentially, we need spaces in which people feel like they can be who they are and bring as much of themselves, as she said, as they feel comfortable doing. So just to pick up on that last point about people accessing the career in itself, I wonder if we could hear a little bit more. How do we make the space safer? I come at this as an ally. How do we make the space better? How do we make it more manageable? Roxy, perhaps we could start with you.
Yeah, of course. So based on my own experiences as a commercial chancery applicant, with all of the other elements of diversity that I have, also being half Persian, not having someone from my family who can help me apply to university or indeed master's courses or anything like that, and finding out that I am neurodivergent, all of these things combined make it just more difficult for people like me to access the profession. There's a particular statistic that I want to bring up that is relevant here. The Bar Council released statistics on pupillage success rates recently, and the success rate for Chancery BAME applicants was 1.4%. So that isn't even factoring in the fact that I'm a woman, the fact that I'm neurodivergent. So for me, that is an unacceptable statistic. Obviously, I would love it to be a meritocracy, but some of the things that I've learned are that different things are taken into account when looking at applications. And for the most part, in chancery applications and commercial applications, it's your grades. And for late diagnosis neurodivergent applicants like me, my grades pre-diagnosis do not represent my true academic ability. And trying to put that across to someone who has no experience of neurodiversity and what it means and how it can possibly impact you, and as Sophie Stevens was saying at the beginning, how it can benefit the bar, indeed. It's really difficult to explain that to someone in just a few paragraphs in the extenuating circumstances box. So what we're campaigning for is just a place for neurodivergent applicants to be able to declare their neurodivergence and make sure that box is looked at, regardless of whether they reach the minimum requirement for admission. Because that is another thing that we've heard, that if you have a 2-1, for example, like I have, then my extenuating circumstances box would not be looked at because I already reached the minimum requirement. However, needs to be taken into account when you look at my grades are still critically evaluated. So that doesn't make any sense to me. And secondly, I would say, apart from recruitment practices, it's really important that the bar is openly visible, visibly divergent. So diversity really needs to be visible at the bar. And we had an event a couple of days ago where it was suggested that if you look at members of chambers and they regularly attend events like this, then that's a good indicator that they're open to receiving applicants from different backgrounds. And I think that goes for all chambers. All chambers could be more visible about being diverse. And so explicitly saying that you welcome applications from neurodivergent applicants is really important, especially as people like me and Sophie and other people are insecure about declaring their neurodivergence in case it's taken negatively. So that would be the start point, I think.
Thank you so much for that really comprehensive answer, and also for offering these very practical solutions to what chambers can do. I wonder if, given Elaine, when you gave your first answer, you were talking about the importance of representation and how we address that, and you do so much work in this space for sort of diversity and campaigning for reform. I wonder if you would have any response to the sorts of proposals that Roxy's put forward, or indeed any thoughts about what was said in particular.
Yes, I was listening very carefully to what Roxy was saying. And I very much agree that we need to look at how we can really benefit from inclusivity in this area, because I do feel that it's something that really needs to be picked up on. And so I think there's a really good point there. I think that generally speaking, we need to normalize, we really need to discuss these issues more. I think one of the ways that we destigmatize issues is to actually discuss them more and normalize them, so that people understand that this is something that brings benefits. The business benefits of diversity, again, so important to emphasize. So I think for chambers to come from a position of actually encouraging, being open to and facilitating applications from neurodivergent applicants is going to be essential. And simply something like stating on your website that you welcome applicants from neurodivergent backgrounds is actually quite powerful, because as we know, this is not a visible issue. You cannot tell by looking at the website who may be neurodivergent or not. So if you're publicizing it, people are going to be far more aware. So I think it's a question of raising awareness and people being open to it and discussing it more. There is a piece of education to be done around this area, I believe, but I'm really positive that we can do a lot more to encourage really understanding in this area. So I'm really pleased to discuss more. Thank you.
Thank you. Thank you for that. I think that education is sort of the key here. It's a slight topic change, but it's still related. Sophie, when you gave your introductory answer, your answer was focused less on the recruitment side of things, but more on how it would inform our practices as people that deal with vulnerable clients. I know I'm a family law practitioner myself. That's certainly something that comes up a lot. In what way do you think further education or further thought about the accessibility of the court system for lay clients, for example, would develop our understanding in this sphere more?
Well, I think it's hugely important. And I've been sort of thinking about the kind of, what are the tools that we've got to ensure that clients who are neurodivergent can properly access the courts. And I do think there's some sort of really positive changes happening that are important and are worth thinking about. So I mean, just looking at the sort of tools that we have, they're kind of blunt instruments in a way. We've got sort of international obligations that are cast often in the sort of the language of sort of disability and vulnerability. And I know that not everyone feels comfortable with that, but obviously we've got Article 6 of the Convention, Article 14 of the Convention, and then we've also got the UN Convention on the Rights of Persons with Disabilities, which, as many of you will know, is not part of domestic law, but used as an aid for interpretation, in committing states to ensuring effective access to persons with disabilities on an equal basis with others. And one of the things that does, it goes on to say that it's got to be a practical approach to this. So it's not just about having the laws in place, but ensuring that there's appropriate training for everyone involved in the field of justice. And that includes judges. We've also got the Equal Treatment Bench Book, which references a number of neurodivergent conditions. It references, in particular, dyslexia, dyspraxia, ADHD, and also autistic spectrum disorders, and it gives some quite practical guidance as to how to ensure that the court system is fit for purpose for those people so that they can properly access it. And in my experience, and I'm working to quite specialist jurisdictions quite a lot of the time, there's the Court of Protection, the Mental Health Tribunal, and the guidance coming from the government to the Mental Health Tribunal is, your judges need to be trained properly to in these conditions, in neurodivergent conditions, particularly autistic spectrum disorders, in order for them to do their jobs properly. And the independent review to the Mental Health Act, for example, currently being looked at, new legislation is going to be coming forward, we understand, quite soon, made absolutely clear that judges shouldn't be sitting on cases involving individuals with particular disorders, including autistic spectrum disorders, unless they have got proven training in understanding those conditions. So I think those are all quite important developments and things that we can look at and see how they work in improving the access that we have to the courts for those who are neurodivergent.
Sophie, thank you so much for that. I can see there are some questions in the chat box. I'm going to reserve those for just when the questioning comes to an end. I have one more question and then we'll open up the floor. Actually, it was really to pick up on what you said about the level of training, the level of insight that practitioners have, or the judiciary has indeed, when they're dealing with vulnerable clients, with neurodivergent clients. Chloe, I was wondering if I could ask you to sort of piggyback on that, because I understand you've got quite a new practice in family law, and that involves necessarily dealing with clients that are neurodiverse, that do present with vulnerabilities, that do have intermediaries, for example. What's your view on the sorts of things that Sophie's sort of said and recommended?
I think it's quite an interesting topic. I think about my client base as quite a junior practitioner, and I'm often instructed for local authorities and mainly legal aid work, for obvious reasons that I don't yet have the experience that most privately paying clients would be after. And because of that, in the arena of family law, I come into contact quite often with people who are particularly vulnerable for whatever reason, and often have mental health difficulties, perhaps as well as or instead of neurodiversity. And I often find that I meet clients who, due to my own neurodiversity, I see traits in, and I do wonder if they're neurodivergent. And because of my own insight into that, I'm able to adapt the way I present information with them, the way I'll hold a conference with them to get information from them, and sort of get really in tune with how they are thinking. And I think the COVID pandemic's definitely had a big impact on that, because a lot of my clients anyway may struggle with doing a Zoom call because perhaps they don't have internet, they don't have a device that they can use for that. So we have to use telephone. And when they don't have that body language that they can try and read, it can be very difficult for them to form that connection with you on the telephone. And I try and use the skills that I found to adapt myself in terms of managing my practice as a neurodivergent lawyer, in the way that I conduct any conferences with them, the way I'll take instructions, and the way I'll ultimately present their case. And I often see clients who perhaps don't meet the criteria for us to consider doing a psychological report or a capacity report, but I still think that the court should be fully aware of the individual complexities that they may have, and considering certain profiles of the people I represent, the fact that they're less likely to be diagnosed officially with something, but they may be neurodivergent and we just don't know. And I think it's keeping all of that in mind, so that even if you are meeting someone who isn't known to be dyslexic, are they perhaps telling you when you meet them, oh, I've forgotten my glasses, so I can't read the paperwork? Because that's something we commonly see. If someone's dyslexic and might be quite embarrassed about it, they might say, oh, I've left my glasses at home. And it's thinking through all of these things and seeing what we can do as practitioners to help those people that we want to represent in the courts. And I think we often need to look at ourselves as a whole profession, and how we have this one sort of linear format as to how we conduct things, in terms of take your instructions, meet your client, go in, do your attendance note next, and sort of addressing that and thinking how we can best serve our clients, and consider how not everyone has had the same opportunity in terms of diagnosis, and how we should do our best to read between the lines in order to represent everyone the best we can.
Chloe, thank you so much for that. That was really comprehensive. And actually, I sort of share your pain in terms of the limitations of diagnosis and capacity reports to prepare those during the course of court proceedings with quite specific information. It sometimes takes away from the global picture and the support that people need. So I can well understand what you're saying. I have millions more questions I'd like to ask, but I think it would be unfair. And at this stage, I should throw it out to the floor. I can see that there are lots of questions coming in. I'm just going to pick the questions, unless anyone wants to specifically answer any of the questions that have come in. I'll pick a couple, and I'm just scrolling up to find some of the ones sent earlier. This one's from Ria, and it goes towards, I think, what Sophie, when she introduced neurodiversity in law, had said. I have often thought that there are benefits in employing those with ADHD and or autism spectrum disorder. What would you recommend in terms of communicating these to the bar at large and not just allies? Is there anyone that would like to take this question particularly? Roxy, go ahead.
I have symptoms of ADHD. I haven't been formally diagnosed, but it was in my diagnostic assessment, sorry. So I can speak on the benefits of having ADHD, and generally the feedback we've had is express those benefits when applying for pupillage, and express it clearly. It's a piece of advocacy after all, and if you can advocate for yourself, then that's the best form of advocacy you can do, really. So that is the feedback that we've got. But in terms of how I would express the benefits that I bring, my ADHD means that I can hyper focus on things, and if I'm into a topic, I can work for hours and hours on end because I enjoy it so much. And it's also really easily managed. So for me, I only have quite mild symptoms. My symptoms are quite strange, actually. I can work in cafes when there's a buzz of noise around me. But if I'm in a library, for example, and someone sniffs, that will put me off my whole train of thought. It's quite bizarre, actually. And I never assumed that I would have it before I got my diagnostic assessment. So in terms of managing that, I just use earplugs when I'm working. And if you're a barrister in chambers, often you have your own room. In pupillage, I know you're sitting with a pupillage supervisor, but we've been speaking to chambers who have been saying it shouldn't be a problem if you express to them that you can only work with your earplugs in. And obviously they'll have to catch your attention another way. But all of these things are easily manageable if you have ADHD and you want to become a barrister. So my personal perspective would be to declare it. And just to jump in on a question another person has asked about whether I have declared my neurodivergent conditions when applying for pupillage, I only declared a few of them last year. So I've applied for pupillage twice now. This will be my third round. Third time lucky, hopefully. But I only declared it to a few chambers because I was so insecure about it. And honestly, there wasn't the awareness that we we have encountered over the past few months, last year even. So I would just say, in summary, be open, be persuasive, and if they don't want you based on that, then they're clearly not the right chambers for you.
Thank you so much, Roxy. Thanks so much for that. There's a question for Sophie particularly, and this is from Jill. Do you have any insight into why autism is singled out as a training need for the judiciary?
Yes, I think I do. And I think, to be fair as well, it's not the only aspect that's singled out as a training need. There are others as well, particularly people with learning disabilities, children and young people. So I think what the concern is based on is that there are a number of people who with autistic spectrum conditions who for various reasons find themselves inappropriately in hospitals, often under the Mental Health Act. There are a host of reasons for that, and they're none of them good. And there are a host of barriers for moving people out of hospital into a more appropriate place where they can live independently. But I think it's really beginning to be recognised that those individuals, firstly, are disadvantaged in that they're very often in the wrong place, and they've ended up there in an emergency, and then it's impossible to move them on because of lack of capacity to provide the appropriate services in the communities as part of that wider disadvantage. And they can also be particularly disadvantaged in the legal process. So I think that's rightly one of the reasons why the tribunal is concerned, and users of the tribunal are concerned to make sure that those who hear those cases are properly informed about the issues. I hope that's answered the question, Jill. Thank you.
Thank you, Sophie, for your answer. I can see there's both a chat in which people are putting their questions, and at the bottom of the Zoom screen, a Q&A section. So I've just been taking questions from the chat. I'm going to move on to the Q&A section. There's a question from Oliver. What do the panel think is the best way to promote understanding of neurodiversity among members of the bar? I'm conscious that Chloe and Elaine haven't had the chance to answer a question yet. So perhaps one of you, if you're... there you go. Can hear someone unmuting.
Yeah, I'm happy to take this one. So I think it can be twofold, really. I think what Elaine mentioned earlier in relation to having chambers actively declare that they are open to neurodiverse applicants is a very powerful thing. Linking back a little to what Roxy said, I personally didn't disclose any of my diagnoses when I applied for pupillage, because in my head I was adamant that they would write me off instantly. I think I was probably still struggling in some respects with my own understanding and awareness of what it is to be neurodiverse. And I think in the past few years, as a society as a whole, we seem to have made some progress in terms of understanding the assets that it can bring, and how labels are just very useful in giving a rough picture as to what your difficulties might be, and then you as an individual can inform that label further. So I think part of it's about that cultural shift and having chambers actively say, we are aware of neurodiverse applicants and we welcome you, because that makes a real tone shift and makes it seem much more welcoming and inclusive. And then I think doing something to sort of back that statement up so that it doesn't read just as a, we are willing to accept blah, 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 or we are committed to anti-racism, or, you know, those kind of blanket token statements that can be really easy to just kind of put a policy statement out on and not really think about. So I think having members of chambers attend events like these and talk openly about it, putting it on your Twitter profile, all those sorts of ways of kind of taking it beyond a website or beyond a pupillage recruitment form or any of those sorts of things, and sort of showing some real activism in that sense. And I think that will encourage people more, because I didn't think too much about my neurodiversity at the bar until I saw the Neurodiversity in Law group, and that's what kind of got me more involved in talking about it. that's what encouraged me to say to the Bar Council, I'm happy to be a social mobility advocate. And now I go to events and talk openly about it with students. And I'm trying from the bottom to try and get everyone interested. And I think if some of our leaders at the bar made some statements about it as well, that would be really positive. I've been working with my circuit on that as well. And a few QCs on circuit have been getting involved, which I think is brilliant. They've been getting involved with Bridging the Bar and with Neurodiversity in Law and other organisations. And I think that's really positive. So if our leaders from on high can make statements about these things, whether that be your family law organisation, your criminal bar, or even just the leader of the bar, and talking about these things, and it will get people to see that it's not just a tick the box exercise, and that we really do recognise the assets that neurodiverse people can bring to the bar.
Thank you so much for that, Chloe. Elaine, there's one question that I wonder if you might be able to answer, because it touches on sort of how diversity and recruitment at the bar as a whole works. So what specific actions do the panel think recruitment committees and chambers should take in order to ensure neurodiverse candidates are not put at a disadvantage when applying and who may be reluctant to disclose their neurodivergent conditions? So it's the other side really of what Roxy was saying.
Yes. this is quite a complex one. It's quite difficult if, for example, a candidate doesn't disclose that they're neurodiverse, then that's going to be difficult to capture and to actually address. So I fully recognize that it's a personal thing about disclosing or not, whether to disclose or not. At the same time, I think there is something empowering about disclosing it. And I think then it's up to the chambers to be committed to step up and to see this fully, in all aspects, including positive and inclusivity. So I think that is really behoving on chambers. And it is a culture shift. It's about being aware and it's about education. I do think the Bar Council can also lead on this in terms of the training that we provide. We very much cover disability, and not everybody associates, of course, themselves as being disabled if they're neurodivergent. I think we need to have more specificity on neurodivergency. And so we need to have that as a separate matter. And generally we need to look at intersectionality more. That's something that I'm very, very keen on. And I think if we can have more awareness about it, that will be helpful. And so if it's declared, then I think chambers obviously should be looking at how they can support, how they can make reasonable adjustments if they are required, so that there is less disadvantage, and hopefully disadvantage completely ameliorated. But I think that does require disclosure. And I think for disclosure to occur, there needs to be some more work done so that people feel they're in an environment where they can actually disclose.
Thank you, Elaine. I think it goes all towards what Bree was saying in her speech opening about how we build safe spaces for people to feel comfortable disclosing. Now, I wonder if anyone specifically wants to answer this question. My Chambers is running an award scheme. Do you have any recommendations of ways we could adapt the application process to encourage people from a neurodiverse background to apply? Are there any takers? Roxy, go ahead.
I feel like I'm answering all of these questions, but seeing as I'm the policy manager for neurodiversity in law, I have had quite a lot of experience of talking to chambers about this. So it kind of depends what the competition is about and what the requirements are for admission or for winning. I would just bear in mind what I said earlier about grades not necessarily being a good indicator of someone's academic ability. Often it's just an indicator of whether they can memorize information and digest it and regurgitate it in an exam. But in terms of the competition, I would just say, as everyone's touched on, be open about it and say that you're willing to accept neurodivergent applicants. In fact, a lot of neurodivergent applicants, I know for a fact, don't declare their condition when they're applying for things like competitions and pupillage, and it doesn't negatively affect them because you wouldn't be able to tell. As we were saying earlier, it's an it's an invisible condition for many people. So first of all, just be open about it. If you can include a box that allows people to disclose their condition, and make sure you look at it and look at that person as an individual rather than just lumping them in as a homogenous group with all of the other neurodivergent people. So look at that application as a whole, allow people to disclose if it's needed, and keep in mind that different conditions affect people in different ways. So without knowing what the competition is, I can't advise further, but those would be my basic tips.
I think it's a short essay question about diversity at the bar.
Well, that's great. I mean, some neurodivergent candidates have difficulties with writing and spelling, so I would make it clear, if you want to encourage people with that particular disadvantage, that an error in spelling will not necessarily mean that they wouldn't get through to the final round of the competition. And just keep in mind that is something that affects some neurodivergent people. But I think lots of people with neurodivergent conditions can speak really well on that topic. So I don't think they would be particularly disadvantaged.
Thanks, Roxy, for that. I think it goes towards a lot of the questions actually we're getting about disclosure and how people feel about what they can rightly say on their applications. I wonder if this might go towards the same sort of answer, but we have a question on whether the panel has any advice on disclosing depression or anxiety on pupillage applications in extenuating circumstances, the fear being that these conditions are seen as weaknesses by the bar, no matter how you present it as a positive. Better understanding of burnout and emotional capacity, for example, better control of mental state via deep breathing, anxiety mitigation, etc. Does anyone have any thoughts they'd like to share on this part particularly? Sorry, I can see Sophie has her hand up. So
yeah,
please.
well, just very generally, it surely would be quite wrong for that to be held against you in any kind of application. And the responsibility of Chambers, as has been said, is to make adjustments and as appropriate, so as to support people in developing their practice. So I think I'd echo kind of everything that's been said so far, particularly sort of very eloquently by Roxy about, you know, the importance of feeling that you are in a position where you can be open about these, you know, these conditions. And it doesn't, and I would really want to second what has been said about it not being just enough to sort of say on your website, well, we're keen to encourage applications from everybody. You know, Chambers have then got to be willing to kind of to step up and ensure that it doesn't stop at the point of inviting the applications, that commitment to diversity goes right the way through the recruitment process, the supervision process, and the development of your practice.
Thank you for that, Sophie. That was a really sort of rounded answer in terms of how people can. Oh, I'm sorry, I can see Roxy has her hand up. Let me stop then.
Oh, no. I just wanted to add, for anyone with concerns about disclosing mental health issues, I feel like I'm in a safe space now, and I can declare this, that my undiagnosed neurodivergence also caused a lot of issues with mental health and with self-esteem particularly. I essentially thought I was stupid. I got very depressed about it. It affected kind of all aspects of my life. So I am very conscious about declaring that. But to be honest, the answer that I've heard when I've been asking people about this is, if you have a condition that has affected your performance in exams or anything like that, or will affect you going forward, it's best to declare it from the off. And generally people are really open to hearing about it. So I wouldn't be afraid about disclosing that. But yeah, I've also asked a question to similar panels like this about disclosing multiple mitigating circumstances. And I think if you have them and they're relevant, then do it.
Thank you both for your answers. Sophie, particularly for sort of giving an indication of how it should be approached from people in the profession, and Roxy, you know, from the entrance point as well. I think it's really important that there's that dialogue going on so people can understand both how to approach it and how it will be received. We've got a really interesting question here. What role do you think solicitors have to play in encouraging and supporting neurodivergent barristers and making sure the bar is more diverse generally? I wonder if anyone wants to come in on this point.
I mean, I can't say exactly, but I think that's a super interesting question. What I can say from my point of view is that was one of my biggest concerns in terms of disclosure. I was very worried when I first thought about doing work around diversity and talking about my own personal experiences that I might see solicitors actively choosing not to have me. And of course, we know that those practices shouldn't go on, but unfortunately, we have seen instances where often women and often women of colour have reported that their earnings and their workload is often affected by what the solicitors are asking for when they call the clerks. And I think it's important that clerks and solicitors and barristers can all have quite an open relationship around disclosure of conditions, not being afraid to talk about these things, but also seeing the big selling points that can come with talking about these conditions. I'm thinking of two cases I've done recently where I'm pretty sure one of the big factors in why they chose me over someone else who was available, given my inexperience in terms of years at the bar, is because of my experience as a neurodiverse practitioner. Was one case, obviously can't say too much, but was one case where one of the young people had some conditions that I have, and they thought it might be quite helpful if I was involved in representing that person, given I have some insight. Of course, my insight alone isn't the only thing that's important there. It's my knowledge of the law and being able to work the two together. But I think that's quite a positive thing. And having solicitors see those sorts of instances where someone's neurodiversity can be a real asset in their ability to represent someone can be part of the change of people being open about these things. Also, we often see that if you're neurodiverse, you're more likely to have mental health difficulties, either ongoing or in the past, often linked to anxiety, depression, whether that be because you weren't diagnosed or coming to terms with your diagnosis and your daily living. And I think that if we can come together as a general profession and think about supporting your colleagues who have some sorts of difficulties and seeing the big assets that they can bring from their experiences with that, it can be a really good talking point. And I would like to see more events where solicitors and barristers come together on these things, because we quite often have, here's events for aspiring solicitors, here's some events for aspiring barristers. We don't really have any kind of holistic approach of what about bringing the legal profession together, whether that be paralegals, SILEX, all the other routes into the profession, instead of the kind of segregation that we sometimes see. I think Sophie wants to add something.
Yes, I just wanted to add this as someone who was a solicitor for 25 years and joined the bar relatively recently. I entirely agree about the ability of solicitors to be allies. And I think it's incredibly important that we have these discussions across the profession. And I think it's a real sign of how things have changed at the bar that these kind of conversations are taking place at all. Because when I started at the bar, those who were at the bar had to show themselves to be invincible at all times. The culture was really, really different. And I think, fortunately, we are in a much more open atmosphere at present, and we really do need to build on that.
Thank you so much. I think that it's really interesting the number of perspectives we're getting on the same issue, because actually we can see that from sort of the junior end of the bar to the more senior end, across the spectrum of different practice areas, we're all faced with the same sorts of considerations. And actually our relationship with solicitors as professional clients as well means that, you know, we've got sort of things to consider in that respect, in terms of our ability to personally market ourselves and how we build our practices meaningfully. Something Bree said in the beginning, actually, about how we bring as much of ourselves to this as we feel comfortable doing, really resonated with me, because I'm sure that, you know, the practitioners and the aspiring practitioners here can relate to the fact that a career at the bar leaves you much more exposed than other careers. Your personality comes into your advocacy. You know, the spotlight being on you, it just makes you so much more open and vulnerable in a way. So all of these things can be assets, as well as things that you feel perennially terrified of being judged for. I know that from my own intersectional background, there are lots of things that make that a terrifying experience. So I'm so glad to be able to sort of facilitate conversation and build a safer space in that respect. I think we've got one more question left, subject to more coming into the chat box. It's actually a few questions wrapped up in one. It says, firstly, I was wondering if anyone knew if law firms and chambers separate mental illness from neurodiversity, and when applying, does it ever count against you? Finally, if you achieved a 2-2 degree, would it ever be possible to have a successful application if certain mental health difficulties during your degree were explained? Maybe we should break those questions down. The first one is specifically about how mental illness is separated from neurodiversity in particular in application forms. I think the point on whether or not it counts against you has sort of been addressed in previous questions, but on that point specifically, does anyone want to come in?
I'll come in and say that this is a point that's been raised with us at Neurodiversity in Law, the differentiation between mental health and neurodiversity, and we've tried our best to clarify it. Yeah, firms in general actually have a greater understanding of what neurodiversity is, because they have their own HR departments dedicated to making sure recruitment practices are fair. So neurodiversity and mental health for firms, I think especially, would be easily differentiated. But yes, as I said before, if it's affected your result, like my own neurodivergent condition and subsequent self-esteem issues affected my result, then definitely declare it, is the feedback that we've been getting, and I will certainly do so in my future applications.
Thank you for that, Roxy. I think that sort of covered both points on that question, actually, both the treatment of mental illness relative to neurodiversity and also what you can do in terms of declaring that and whether it works against you. I wonder if anyone has any final comments on that particular question.
I just wanted to say something off that as well. I think that's right. I think chambers do not necessarily break it down. And as I was saying before, I think we need more specificity. And even I was looking at the Bar Standards Board's latest figures on diversity, and it talks about disability. It doesn't break it down. So again, I think we need to break down and have a particular category for neurodiversity. And it would be very helpful, I think, to have more data on, you know, the actual spread of those with neurodivergence at the bar, at all levels across the bar, because I think it's quite unknown. Because not everybody counts it as a disability, and it's not necessarily broken down. So I think generally we need to have more discussion, more awareness, and more information education on this for the bar and for chambers in particular.
Thank you for that, Elaine. On the topic of further education for the bar, and perhaps you will answer this, or perhaps everyone could give some indication, just as closing, and in line with Themis's maxim, it's been a very long day, I'm so sorry. I was wondering what you all felt about the facilitation of intersectionality at the bar. What more could we do in that sphere?
I think it can be important to break down individual characteristics, but also consider how they all come together. But there is more to us than one particular aspect of our identity. And I think it's so important to have individual spaces that are related to a particular aspect of your identity. But it's also important that once we've thought about that, we can also bring it all together. So I am much more than the fact that I'm neurodiverse. I'm a caregiver to a disabled person. I'm a woman. I'm heterosexual, and I'm from a working class background, and there's many more aspects to me as well, but all of those come together to inform my view of the world and inform who I am as an advocate. And I think it's so important that we focus on the areas where we're really lacking in support for individual things, whether that be more women and women of colour at the bar, particularly in areas like Chancery, or whether it be thinking about how we can support pupils and people already at the bar to disclose that they're neurodiverse. And I think we need to consider all those factors individually, but also think more globally, yet again, as I keep going back to, because there's so much more to us than one individual aspect. And whether someone is willing to report something will be greatly informed by who they are overall and the many threads that come together to make them the tapestry of that person. And sometimes we can focus so intently on just one particular aspect of that person, but we can lose sight of them generally. I think I'm thinking of when we talk about disabled people, if you talk about condition first language rather than person first language. I have Asperger's, that's my official diagnosis, but I am not Asperger's. And I think sometimes when we try and do something really positive, it can have a negative effect if we don't recognise that we're much more than the sum of our parts. We're an equal human being with many interesting threads to us. And also that the law is just one part of us. I'm sure we all have lots of interesting hobbies as well, and interesting families and interesting prior experiences to the law. And I think put all of that together in a nice little melting pot can make everything much more interesting, but also much more useful.
Thank you, Chloe. I really resonate with what you're saying about where we're not the one thing that people tend to pinpoint us as. You know, I come at this as an ally in terms of neurodiversity, but I know, for example, being a woman of colour, the way I interact with my gender is very racialised, the way I interact with my race is very gendered. And, you know, I know that people from different intersectional identities will have that experience as well. I wonder if anyone had any closing thoughts on what Chloe said, or the general sort of thrust of what we need to do to facilitate greater intersectionality before we wrap up.
I just wanted to say that as an equality lawyer, it's one of my big disappointments that the Equality Act, which has compound discrimination in it, is not enacted. The fact that it's not enacted, though, does not negate the fact that we are, you know, a total. We're not separate identities. We're all one, rolled up together. I'm not a woman who is black. I am a black woman. And this is what annoys me about the Act not reflecting how we relate to each other in reality in society. We all do need to have a better understanding of intersectionality. I think it's the future. Kimberly Crenshaw was right. We all need to get to grips with it. It's, you know, it's essential. If we really want inclusivity and equality at the heart of what we're doing, then we need to understand intersectionality and put it right on top of the agenda. Thanks.
Thank you, Elaine. I can see Sophie's unmuted, so I wondered if she wanted to share something further.
Only that we need to continue having conversations like this. It's really inspiring. It's particularly inspiring to see people at the very start of their careers working in this area and being so effective, such effective advocates. And I did wonder if either Themis or neurodiversity in law is also going out to schools and talking to people who haven't even thought about coming to the bar or even the legal profession, and if not, whether you've got plans to do so.
I can probably speak very briefly for Themis on that. We are in our infancy. At this moment in time, we are still trying to reach out to the bar. But you're completely right, it's so important. And I think that that's definitely something that we should be doing. All I would say is give us time, but we will get there, and we will definitely be reaching out to everyone to make sure we can improve that access. That's a great idea, thank you.
Absolutely, I think that's a watch this space on that one. Look, short of any further questions that I don't see coming into the chat box or the Q&A box, I just want to thank you all for giving us your time and appearing on this panel. Elaine, Sophie, Chloe and Roxy, you've just been absolutely outstanding, and I think the quality of the conversation that was had tonight has definitely given people a lot to think about, whether they're allies, whether they're thinking of applying, and they identify as neurodiverse. It's been such a pleasure and a privilege to be able to moderate the conversation and to learn as much as I have myself, so thank you. I'd also like to thank, of course, Bree and Sophie again for doing our introductions. I'd like to thank Beth and Luna as well, who is under a different name, I think, unless she has a second identity that I don't know about. For some reason, she's on Zoom as Raimonda. But that is Luna, one of our Themis founders. So thank you so much for the hard work that everyone's put in. Thank you to you all for attending. And I hope that you sort of got something out of this in terms of just something new to think about. I'm going to hand over to Beth to do the final wrapping up. But really pleased. Thank you.
Again, all I have to say is more thank yous, and please join us. We are Themis. Of course, there's also Neurodiversity in Law. There are so many other organisations. We've been asked if this recording will be available. It will be, not 100% sure exactly when that'll be, but check out all of the social media platforms on which you found this event, and you'll be able to watch it back again, particularly if you missed any bits of it. Otherwise, what a cracking night. What a fantastic way to end 2020, to show there is, after what has been a pretty pants year for most of us, a lot of hope and a lot of progress to be made. So my final thank you is to Srishti, who has done a cracking job. She admitted that it was her first time moderating. Had she not admitted it, none of us would have known. That was brilliant. So thank you again, everyone, for joining us, and have a lovely VAC if you get some time off. Otherwise, we hope you'll join us in 2021 for more events with us, Themis, or with Neurodiversity in Law. Thanks.
Thanks, everyone.